Hmm. Good afternoon. This is the Judiciary Non Civil Committee meeting. We're here to consider 4 measures. We'll begin with Senate Resolution 774. Chairman Stone.
Thank you, Mr. Chairman, committee members. Appreciate you allowing me to be here today. This is you want me to proceed? Okay. This is a resolution for a joint study committee on adoption expenses. In working closely with Representative Reeves and others in my chamber, it became apparent to me that we searched in vain to find any regulations or that set out guidelines or procedures for allowing the approval of adoption expenses. Now, it first came up as an issue in HB 159 because we were extending the right to such expenses in private adoptions, private attorney adoptions. But in our research, we found there were no guidelines in agency either. So what this will do is help eliminate ambiguity in the implementation of our policy now to allow reasonable expenses. That is, what are the guidelines for determining what are reasonable expenses, and what are the procedures for having them approved, because both are unaddressed in either the statute or regulations. So this had broad support in the Senate, all nearly unanimous in co-sponsorships, over 50 co-sponsorships, and it helped us to pass HB 159, knowing that this issue, because the state has such a strong policy regarding discouraging illegal inducements, that it would behoove us to have a brighter line in determining where that cutoff is and how to determine it. So this is aimed at formulating good policy. It's not something that we need to necessarily wait on, because agencies have been in the business of allowing expenses, paying them out for quite some time. And I think before we go down too far down the path, allowing the private attorney adoptions to do the same, we need to have some clarity and guidelines as to what's reasonable and how to determine that. Be happy to answer any questions.
Any questions for the author? Ms. Kendrick.
My mic doesn't work.
You're on.
This was a question just generally, maybe not for the author, but am I missing the criminal law aspect of it because it's in our committee? Am I missing something, or just where it ended? Okay.
It's where the presiding officer has assigned it. That's my story, and I'm sticking to it. That's all I got. Any further questions for the author? Okay, Ms. Gonzalez, did you have something? Sure, press the button.
No.
Yep.
Got it. Okay. In the study committee, will it be the same guidelines for both the agencies as well as the private adoptions?
I believe so, but that's just my personal opinion. I believe they should be across the board.
Okay, thank you.
What's the pleasure of the committee? Ms. Ballinger moves due pass of SR 774 LC 440760. Is there a second? Second by Ms. Kendrick. Are there any amendments? Seeing none, any further discussion? Seeing none, all in favor of the underlying motion signify by saying aye. Aye. Opposed? The ayes have it. The motion is adopted. Thank you, Senator.
Thank you very much.
Senator Kirk? That's clear.
Thank you, Mr. Chair. I bring before you Senate Bill 369. This was heard in previous hearing, but what it simply does is restore a $5 fee that was, when we did the criminal justice reform in the state of Georgia, that $5 fee didn't transfer over to our diversion options or diversion courts, such as your drug courts, family courts, and mental health courts. And so previous to that, $5 would have gone to someone who went through the court system to the POAB for their retirement. And this change, when they could choose the diversion courts, cost POAB about $4 million a year. And so this would restore that to POAB. It is not an added fine. That's one of the things that people think, well, this is an added fine. We had testimony. The municipality set the fee for their diversion courts. It's around $500. They can charge by code up to $1,000, but most of them on average around $500. And so they can choose to charge maybe $505 if they so choose, but we had testimony in committee in the Senate that I think it was Cobb County, don't hold me to that, but that was a larger county in Georgia, said they would not increase theirs. They would just pay the $5 out of what they're already collecting. You may hear some testimony that this $5 is, well, first of all, they'll say it's an add-on. It's not an add-on. It's just going to come out of what's already being charged for those diversion courts. And then secondly, you'll hear it's unconstitutional. Well, if that's true, then the entire $500 is unconstitutional, so I disagree with any arguments along those lines. I'll be happy to answer any questions of the committee.
Let's, before we get to questions for the author, let me get the report of the subcommittee chair, Chairman Setzler.
Thank you, Mr. Chairman. As the senator said, this arose from an unintended consequence. The one thing we asked in subcommittee was, was there local government opposition? Georgia Municipal Association stood up and said this was not an issue for them. They'd sort of been part of this discussion. So with that, we sent it forward with a unanimous do pass recommendation.
I just asked Chairman Setzler if the clerks had testified in subcommittee, and he responded they did not.
They did not. No, we have not had any pushbacks from the clerk. I have not as the author. I haven't heard of anyone else.
Yeah, I have not been contacted for what that may be worth.
Okay.
Questions for the author from members of the committee? Seeing none. Thank you, Senator Kirk.
Thank you.
Is there anyone here who'd like to be heard in opposition to Senate Bill 369? Ms. Dotson.
Good afternoon, members of the committee. My name is Marissa Dotson. I'm the Public Policy Director at the Southern Center for Human Rights. I'm also an attorney. I emailed you all some remarks about this bill earlier this morning. I just want to clarify a couple of points that were made by the sponsor. The first issue around constitutionality. Can you all hear me okay? I feel like it's, all right. The issue around constitutionality is Georgia's Constitution, Article 1, Section 1, Paragraph 24, says that the prohibits the imposition of any fines and fees for a criminal defendant until after they've been convicted. Why this is different than the pretrial fee, as the sponsor mentioned earlier, is because it is one thing to say, if you were going to go through a program, we're going to assess the cost or transfer the cost of that program onto you. This is different. This is a penalty. This is the idea that we are saying we are putting on an individual, because they are going through a pretrial diversion program, a fee or a penalty that is prohibited by the Constitution. It is not about going towards the cost of the pretrial diversion program. It is not about allowing the tax issues or revenue issues for the community or the local jurisdiction. We are talking about trying to fund law enforcement retirement funds with this money, which is why it's a constitutional issue. The other issue I wanted to raise with you, excuse me. The other issue I wanted to raise with you is this $5 add-on. He said that this is not considered an add-on. It will be a part of the $500 if the local clerk decides they want to do $495 for the course and $5 for this fee, they can, but we know that this is not how it will be. This fee will, in fact, be passed on to the individuals going through this program. And I just want to call your attention to the fact that most people who go through the criminal justice system are poor. It's not a good use of our resources to think about putting a requirement on taking care of law enforcement and their families by passing this cost on to criminal defendants. We at the Southern Center, just like you all, are very intentional and concerned about how our law enforcement community is taken care of. We think that that the officers and their families deserve to be taken care of, but we don't think that this should be something that's passed on to the criminal defendants. Because the legal system is a public good for all members of the community, it should be funded as such through the state's general fund and not, again, a pass on to individuals who have not been convicted of a crime. And there are, in fact, constitutional issues with moving this surcharge to pretrial or pre-conviction.
Vice Chair.
Thank you, Mr. Chairman. Thank you, Ms. Dotson, for being here as always. I got your email and read it, and I understand the language that is quoted in the email that you sent. But however, I mean, I can just tell you from firsthand experience, I've personally been involved in what I would at least say is literally hundreds of cases of persons who are under a first offender sentence or a conditional discharge 16-13-2 sentence, all of which adjudication is withheld, and all of which a fines and fees are administered and collected just as if they were on probation where there was an adjudication. So I'm not sure where the disconnect is between the language that you sent and the long-standing practice in the state of Georgia on this, but I disagree. I disagree with your analysis in light of knowing how we treat the accused in several types of cases where adjudication is withheld. And so the other thing I want to say is clarify I guess if I'm right or wrong. I believe that what Senator Kirk said was that in some cases, I think you said in Cobb County that
Large county.
maybe I think you might have said Cobb County. You're not sure, but either way, that there are some counties that will take the $5 out of their application fee, and some, I guess, that may not. But I guess what I would submit is that $5 is not a lot of money, and so whether the county is going to take that out of the application cost already or it's going to be added on, I don't really see that as a real big deal, because it's frankly not that much money, and we've been so deliberate in giving opportunities for folks who have been accused of criminal violations to participate in diversion and accountability court programs that have a favorable result if they're successfully completed, an extremely favorable result. And I don't think that a $5 fee, kind of considering the impact that this has had on the annuity fund, I just don't think it's much to ask for. So.
I appreciate your comments, Vice Chairman. I would just want to respond really quickly to I agree with you around the first offender or conditional discharge statute. I would say that it's a little bit different, though, because in those situations you actually have to plead guilty.
But adjudication is withheld, and those are the words.
I don't dispute what you're saying, and
I use is adjudication.
I don't want to. I guess I don't disagree with you. Mm-hmm. I think that this conversation around how fines, fees, and surcharges are used to fund our law enforcement community is its own conversation. I think that I'm putting this out to you all now around pretrial costs because I think that this is the most egregious example of how we might be changing around the way our revenues go for our law enforcement community. So I agree with you there. I would only say that I think that in keeping with our Constitution and our issues around how we fund law enforcement communities, that we should not think about doing these fines and fees and surcharges in this way. I would also push back a little bit and say that I understand $5 might not be a lot to you or to me, but if we continue on this road of trying to figure out how we can continue to add fines and fees, we will make these programs so that individuals cannot afford them. And arguably right now there are constitutional issues with asking somebody if you can pay for a pretrial diversion program, you can go through and get your case dismissed. But if you cannot pay to go through this program, then you have to actually face a trial and possible guilt. So this is an issue of wealth-based discrimination. If you can pay for it, great. If you cannot, you suffer the consequences. And a lot of people who go through the system, as you can see in my email, are people who are unfortunately, $5 is a lot more than it is to you or I.
Chairman Cecily.
Thank you, Mr. Chairman. Mr. Dodson, appreciate your presentation. We did not have a chance to talk about this in subcommittee, so we'll address this for the first time.
Yes. I'm sorry, Chairman Setzer, I had to leave that day. I signed up to testify, but I did not have a sitter, so I had to leave.
I understand. Isn't it true that this $5 though is being, before the diversion program effect started to kind of be recognized, isn't it true this $5 paid before when people were going through the full process?
Say more about that. What do you?
But before this got caught up in the loophole, as I will call it, for diversion programs, this $5 was being paid previously. So this is not some new novel thing we're bringing. All we're doing is reestablishing that which should have been ported over to the diversion programs when the statute was passed. It was just a miss technically that this didn't get carried over. Is that not true?
I think that it is true that this fine or the idea that these funds were going into the retirement fund was happening before, but it's very clear that it was only upon conviction. And the issue is when folks aren't, if it's not resulting in conviction, how are these revenues being, how is this revenue being granted or given? And so I think that is the question. The question is, and the presentation from the sponsor and some folks that testified to this before said, you know, what's happened is we now have, we use pretrial diversion more than we ever did before, and now folks who would normally have ended up with a conviction aren't getting a conviction anymore, and so we're losing out on this revenue. And so I think that's how we got here today.
I hear that, and Mr. Chairman, I direct the question to the lady because, you know, the idea that it's a $5 increase. It's really just sort of a restoration of a $5 that had always that had long been there, and we're sort of reestablished. It's now tracking back as it was initially intended to.
For people who were convicted, yes.
Well, so again, if they're asked, do you want to go through a conviction or would you rather go through this diversion program? As the vice chair alluded to, they're clearly choosing the diversion program for many good reasons. And I think if you hold aside the constitutional question just momentarily, the $5 to me seems to be a wash. It's just it's moving from where it was to where it rightly should be. It's just kind of tracking these cases. So I don't know that the $5 means much. And I think on the constitutional question, I don't know that if as you've alluded to and as the vice chair alluded to, that there's not if in fact you're right, there's a constitutional question, it's not a much larger one than these dollars. It perhaps, you know, would call the whole structure into question when you've got these pre-conviction adjudications. So I want to separate the question, Mr. Chairman. I don't see that this $5 is a restoration, not something new. And you know, I appreciate the issue. I just don't know this is one that's.
Chairman Setzer, just one really quickly. One thing though is that there are people who are going to go through the pretrial diversion program that weren't guilty of the offense, but because there are lots of reasons that people will choose pretrial diversion. And so the point is that there are individuals who may not have been convicted if they went all the way through, who would have avoided this $5 penalty because they weren't convicted for what they were accused of. What we're doing now is making it so that every person who goes through pretrial diversion, whether or not they would have been found guilty later on, will be required to pay this $5.
Isn't it true, though, there are defense attorneys in the state today that will tell their clients to plead guilty because there may not be one today, but it happens regularly because as they look at the landscape of what they're subject to and what they can prove, what they can defend against, there are people who plead guilty and take a plea deal because they're afraid to go to trial and what can happen to them. So, I mean, we're not insensitive to that. I think to suggest this is something novel and out of step with, I'm not sure I'm persuaded by that.
I understand. Thank you.
I see no further questions. Thank you, Ms. Dodson.
Thank you for your time.
Is there anyone else who'd like to be heard in opposition to Senate Bill 369? Seeing none, what's the pleasure of the committee?
Move to pass.
Vice Chair moves due pass of Senate Bill 369. LC 41138-2S parentheses SCS end parentheses. Is there a second? Second by Ms. Ballinger. That's right. Are there any amendments? Seeing none, any further discussion? You have a minute? Mr. Trammell?
Thank you, Mr. Chairman. I just want to say on the bill that as a lawyer who sometimes appears in criminal cases, you know, I appreciate what the lady says about the constitutional argument. However, that is not an argument that I hope gets prosecuted very far, because the times that we have used pretrial diversion to assist clients have been in cases where they're charged with a marginal offense and a larger offense. And pretrial diversion has sort of been a godsend, because if we had to move forward, they would wind up with a conviction on their record, even though it may be a case the prosecutors don't have a huge appetite to pursue. It's not a case where they're at liberty to null pros the case. So I understand the argument, but I cannot reconcile philosophically. I mean, I think pretrial diversion is a process where there may be disparity about individuals who choose to be there, but my experience has been that it at least is filtering out defendants who otherwise would be caught in a system and gives them a way to get out and get a second chance. So I'm going to be voting in support of the measure.
Any further discussion? Seeing none, we've got a motion and a second on SB 369 LC 411382 SSCS. All in favor say aye.
Aye.
Opposed? All those in favor, please rise, stand, and be counted. No, it's not stand up, just an expression. 6. Opposed? The ayes are 6 and the nays are 3, and the motion's adopted. Thank you, Senator Kirk.
Thank you.
If you wanted to stand up, you could, but you don't have to. No. Just throwing a little parliamentary every now and then. Just keep everybody on their toes. Just keep them on their toes. Okay, sorry for the delay. Let's call Senate Bill 336. Is Senator Underman here? There she is behind the column. Welcome back.
Thank you. Just don't sing that song, Don't Walk Away, Renee. You go far, you don't
There's
go that
zero likelihood of my singing at any time in the next. Mr. Reeves can actually sing.
far. Oh, I know he can. He can play too.
Yeah, sure can.
Okay, thank you, ladies and gentlemen, and Mr. Chairman. I appreciate y'all working on this bill, and I understand there's a little confusion about it, but
We're gonna, Senator, what we're gonna do is, and I know
you're
there's,
gonna let it. y'all
we're gonna go
describe it?
ahead. We're actually gonna go ahead and work off the substitute
Okay.
and the newest substitute members to make sure that we're all reading off the same page is 8018S. Is that correct? No.
8037.
Okay. Here, take that. Make it yours. It's 8037S is the substitute that we're going to be hearing. What we're going to do is Senator Underman is going to describe her underlying bill. I'm then going to go ahead and recognize Chairman Welch to speak to a pared down version of his bill that this committee previously considered, which was House Bill 623 and still is House Bill 623. And it's going to be offered as part of the substitute of SB 336 8037S. So I just want to go ahead and set that table first, but then so that members are aware of what we're doing and what the posture is, but then I'll go ahead and recognize Senator Underman to speak to her underlying SB 336. Senator Underman.
Thank you, Mr. Chairman, and thank you for the subcommittee working on this bill. This bill prohibits an electronic service provider from providing notice of the subpoena to the subscriber or customer of the service. Vernon Keenan testified, and this bill is being sponsored and asked to for me to bring it forward with the Children's Task Force, Children's, what's it called? Children's Child Exploitation and Computer Crimes. This is usually done in conjunction with the sting operations when they're trying to capture people who are wanting to abuse children with sexual exploitation. And I understand that the GBI and the FBI fingerprinting, the House Bill 623 is being laid on top of it. And I was working off of 8037S. I haven't read this other one, but I agree with that fingerprinting. I go way back, probably before some of y'all were born, with fingerprinting. And remember when I was mayor in 1983, I believe it was. And I know that when you're working with children and volunteers and nonprofits, that fingerprinting is a very good thing, and it does catch people with a prior history of child abuse. And if I were sitting in the House, I would have voted for that bill. And I'm in complete agreement with that bill being put on top of this bill.
Thank you for that statement, that clarification. That helps us. Let me get a report from the subcommittee. Chairman Setzler.
Thank you, Mr. Chairman. Subcommittee passed out the LC 298081S. As the chair alluded to earlier, that was the full version of Representative Welch's bill. I felt like the subject matter, GBI electronic records and GBI electronic records of fingerprints was about as close of a fusion of subject matter as we normally see. Thought it was appropriate to bring those together. I think substantively coming out of our floor debate after 11 p.m. on a crossover day, there was just a really mass misunderstanding in our body of the underlying subject matter of this bill. I've always been counted myself quite the privacy advocate, and I think that's the legislative career of being somewhat intense about that issue. I just think the misunderstanding around this is such, we need to revisit this as a legislation in a way that our body can understand the underlying policy that this has no difference of how the frequency of information going to the FBI. This is just a circumstance where, as the lady alluded, that for people for whom information's collected prior to taking a licensed position or a position in state government, that we just maintain that through the term of their service. And 8018S recognized that and moved out accordingly. If there's any other questions that Chair has about subcommittee discussion, I'm glad to address those.
I appreciate it, and I appreciate the report. We are going to be working off 8037S, correct? Just to make sure the members are clear. I can't. There's no way to overstate the vigilance that Representative Ed Setzler has had on our committee over the last more than a decade as it relates to privacy, as it relates to personal information being shared, taking a very skeptical, very healthy, skeptical, cynical, jaundiced view of the government's ability to maintain security as it relates to data and data security and privacy. And I think it's a well-placed concern, and that's putting it lightly. And so hearing that, obviously we're going to have Chairman Welch come and explain his revised version, but I can't really put into words when something has the Ed Setzler stamp of approval as it relates to privacy, especially as it relates to big data and government. That is something to take very seriously and to take notice of, for sure. With that, questions for Senator Unterman on the underlying bill on her SB 336 as it came over from members of the committee? Seeing none. Senator Unterman, thank you.
Thank you.
Appreciate your coming over and your patience. You're released on your own recognizance if you'd like to be. You're welcome to stay, but you don't feel the need to. Please.
I'm very interested in this bill, and
Okay.
I feel like if it is in totality explained correctly, that those of us that have worked on human trafficking and child exploitation, which there are several in the House and the Senate, that I feel very confident in the bill, and I think it can pass through the House as is.
Thank you, Senator. Appreciate it and appreciate your accommodation. So let me call Chairman Welch up to the table, and what I'm going to ask Chairman Welch to do is to walk us through 8037, what it does do, what it doesn't do, and to really draw a contrast on where we've been and where we are now on this issue. Chairman Welch.
Thank you, Mr. Chairman. Members of the committee, it's good to be before you again. The version that you have, 8037S, narrowly draws back the wrap-back version of the bill that you saw at House Bill 623. It focuses now on only just a few agencies: DCAL, DHS, DCH, and DBHDD. So the sections that are in this bill are the same sections that you saw before, but limited to just those agencies. It does not go and is not as fully comprehensive as it has been before. And the reasoning here is because those agencies license, regulate, and employ individuals either through contract or direct employment, individuals who oversee our most vulnerable, our children and our elderly. And so that is the sum of the changes that you see before you, Mr. Chairman. And I would like the committee's favorable consideration with respect to the sub.
Questions from members of the committee for Chairman Welch on his revised language that you see in 8037S. Questions from members of the committee for Chairman Welch. Ms. Gonzalez.
Can you please go over for me lines 68 through 80, where you add this new subparagraph to section 35.333?
Would you like me to read it to you? How would you like me to go over it?
What's the intent behind the paragraph?
This right here, this paragraph here, allows for the registration of the fingerprints for the criminal background history. That be authorized to run those checks in state and under state and federal law. And this deals with those agencies that employ, place, register, or permit, or license within an agency. So, for example, if you're a child caring institution under the Department of Community Health, the Department of Human Services, there's a sub-department that deals with the licensing of these child caring institutions. Those child caring institutions must have their employees fingerprinted to the extent that those employees are handle and oversee and supervise children that are in the care of the CCI. So that's one example of a licensing requirement that is required by the state law currently, and currently requires that those employees be background checked every 5 years. So a fingerprint is required for each of those members, those employees that are licensed through that department, and a fingerprint is taken every 5 years for those employees. Instead of doing that every 5 years, we would do this once and not every 5 years, and that data would be maintained by the GBI.
But this only refers to those agencies that you pointed out before, right?
Yes, ma'am, that's correct. If you go through the sections that begin in Part 2, and you'll see Section 2-1, and then the remaining sections all go to the specific code sections whereby we require a fingerprinting. In some of these cases, it's every year. For decal workers, every year. For others, it's every 3 years, and for other organizations, every 5 years. So you're constantly taking that data, that fingerprint data, every 3, 5, or even every year, resubmitting it to GBI and resubmitting it to the FBI for a background check under current law. This would change that to allow for an exemption so that it's a one-time submittal to GBI and FBI.
And every time it says participation in the program, it's relating back to what program?
It's relating back to the RATBAC program, which is defined in the first sections of the bill under Part 1A.
Ms. Kendrick. Mr. Bodie.
Yes, Chairman Welch. I just want to kind of go to lines 92 through 98. I guess I'm just trying to get the understanding. Is this basically stating that when an individual is no longer maybe employed with the organization or the agency, that 10 days after that, that information is going to be transcribed to GBI, and then the GBI is going to transcribe it to the FBI, and the FBI are then going to remove those fingerprints of the person no longer working?
We cannot pass, under this legislation, this would require that the GBI would delete that fingerprint data for that employee or license holder or director, however it applies throughout the code section. This provision here requires that they remove those fingerprint data from the GBI and then notify the FBI accordingly. Under the FBI program, they're supposed to remove that data as well.
But basically, this statute doesn't address, because we have no jurisdiction over the FBI, and the FBI actually deleting those files. The only thing that we know for sure is that the GBI will delete, but the FBI should delete.
That is correct. Under federal law, for the federal program, upon notification, the FBI is required to delete that information. But as you're pointing out, we have no jurisdiction over the governance of the FBI, so the law, obviously the bill does not state that.
Do we have any evidence from anecdotal, quantified, or otherwise that they would not fulfill that responsibility?
No, we don't. And this bill has been comprehensively reviewed by both the GBI and the FBI as well with respect to this exact language.
Can the GBI address just very quickly any concerns that they may have about the ability of the FBI to go ahead and comply with what's already federal law?
We don't have any information that suggests that they're not. I mean, we're required to delete it, which we do, and then
Right.
It's outside of our scope, but we just know that we do notify them.
But over the course of time, obviously, law enforcement agencies, I mean, there's state-federal communication. Has this come up as an issue with them in terms of they're not fulfilling their responsibilities to delete information they're supposed to delete, to your knowledge?
We don't have any examples or instances that can be cited as them not doing it.
Okay. Yeah, Ms. Gonzalez.
Yes, thank you. On line 144, it states, "The timeframe set forth in this subsection shall not apply when fingerprints have been retained by the department due to its participation in the program." Are those timeframes the 10 days that we were talking about?
The time frame set forth in the subsection, no, ma'am. This time frame is dealing with I believe this is a 1-year requirement or decal. For every year they're supposed to re-fingerprint employees. And I have to look back at this. This deals with the application of, potential employees that would be hired, and there has to be a background check done for them, and it has to be done on an annual basis. You'll see that in the language at line 117. You'll see that it says dated, it's clearance date not more than 12 months old. So when they check that data, you're constantly, every year, having to submit a new background check for employment. That would no longer apply if you subscribe, because it's a one-time submission.
So it's just that annual,
That's correct, yes.
not the 10 days.
No, the 10 days is when it's supposed to be removed from the GBI database upon termination of employment. Those are two different timeframes.
Is that the only major difference that you have between this and what was House Bill 623?
The major difference is the deletion of every other code section that authorizes or requires actual fingerprinting and limiting it just to decal, DHS, DCH, and DBHDD. So
Let me ask you to go ahead and repeat that.
yes, so the bill that you had before you in the House was a comprehensive, every single fingerprinting provision. We added this exemption. We allowed for a one-time submission of fingerprinting to be part of the database. So as Representative Gonzalez will remember, we had some discussion about, for example, lactate licensing. For that particular license, a fingerprint background check is required. That is no longer in the bill. So this version of the bill takes all those other applications of background checks out and leaves it to a very narrow focus, just focusing on DBHDD, DCH, DCH, DHS, and DECAL, sorry. So agencies that are overseeing and protecting our elderly and our youth would have the option, and those agencies may choose to subscribe to the system if they elect to do so. It's not mandatory. It would be at their option to decide.
Mr. Setzler.
Hey, Mr. Chairman. Mr. Chairman, I want to just say to maybe the members of the committee, if there's concerns about the FBI hanging on to information that we send to them, as the gentleman said earlier, and it's Representative Welch, these prints are collected before someone steps into a position of responsibility, and it goes up to the FBI right now for a criminal check, does it not?
That's correct.
So if there's concerns for that which goes up does not come back down, and I, by the way, actually subscribe to that. I personally believe that if something goes to the federal government and is checked by FBI, I believe somewhere in the federal law enforcement structure, I believe it's probably kept. But this bill has no impact on that whatsoever. Because before someone takes one of these jobs today, isn't it true, that print goes up, it's scanned by the FBI, and if it does not come back, if they maintain it in their database, and it goes somewhere else, it's happening today. Every single one of these people is having their print sent up today. Every single one of these. So whether we maintain it for 5 years or whether we do what we're doing today, it has no impact on whether a print goes up or not.
In fact, it actually reduces the frequency in which you send prints. So you send it once as opposed to every 5-year, or every 3 years.
I might take issue with some people on the committee. It's the point I'm making. It's immaterial whether you believe that the federal government gets rid of those prints or not, because every single one of these people today that takes one of these jobs, the print goes up and is analyzed. So if you believe it stays there, it's staying there today. It's not. This bill doesn't change that one single bit. So to say this is somehow empowering the federal government to take prints and hang on to them in ways they don't today is just patently, it's nonsensical. That's sort of the basis of this bill. The policy question is, I believe, where should we be taking prints? I believe we should only be taking prints where they're really, really needed, okay? But if we take them because they're needed, we need to use them in ways that are high leverage and accomplish a meaningful law enforcement purpose, and that's what this bill does. Your bill recognizes that if we take a print for somebody, we scan it, do they have a criminal history? If they've got one, it'll flag it when we bring them into in their role, and it's not taken for another 5 years. What this bill does is it maintains it so that while they're in this position of great care and trust, whether it's a foster parent, whether it's an agency person, whether it's a child welfare worker, all those positions of responsibility, today we check them before they start the job or they take the role, and we don't visit them for another 5 years. So if they're offending in other states and committing crimes, there's no means for us to find that out real time now. What this bill does, it allows it to be maintained not just at the state level, but maintained at the federal level, so real time if they commit a crime, isn't it true?
That's correct.
Chairman Welch, that we can catch them right then. So if you are concerned from a privacy perspective about what Washington does, this bill has no impact on that. What it does do, though, is that if you recognize we only allowed to collect fingerprints in certain cases, and these are ones that are prescribed in statute, this allows the collection of those prints to be meaningful, be used in meaningful law enforcement ways to provide real-time protection for our kids. That's all this bill does. It has no impact. If you believe that when that which goes to the FBI is shared with some other agency, it's being done today. This bill has zero impact on that, Mr. Chairman.
Thank you. All right. Since we've gone through Ms. Gonzalez, I'm going to give you the last word.
Thank
Maybe
you,
a
Chair.
short word, since this is your third round.
I'll take issue with that statement later. But one thing that I do want to make very clear is that what does change with this bill is this ability to retain these. And I am still not satisfied with the security in place to retain these. And I think I have made my case pretty clear, and the GBI did testify that they do not retain them now. This bill would authorize them to retain it. And you're right, we can't decide what the FBI does, but we can decide what happens with these prints in this state. I want to protect these people. I know that when a fingerprint is leaked, it can open a car, it can open a home, it can open a database, it can open a phone. I am still not satisfied that we are securing them sufficiently with this bill. I appreciate the fact that you reduced it to what are most important, and I have no problem with the fact that we need fingerprint checks for these individuals in order for them to get the job. But I still want to make sure that if we are saying that we can retain this information, what are the security features to keep those protected?
Chairman Welch, you want to address that, or does the GBI want to address that directly?
The bill mandates that they be maintained in a secure and separate system. That is the mandate of the bill. Obviously, I think GBI shares your interest in maintaining a secure facility. I don't believe I'm going to convince you that they will do that. That's a judgment call for everyone. But I can tell you that the security of each and every child that's in a daycare center, the security and well-being of each and every senior adult that is in a healthcare facility, the well-being of children that we place in foster care, or those that we place in child care institutions, that is a real need and real security protection. And we have instances, and GBI can testify to those instances, where individuals have cleared the background check and after the fact committed a heinous crime that would justify removal from the license or from employment. And those are real cases. They're not speculation. And that's what this bill is designed to do, is protect those individuals. But I don't believe I'm going to convince you that the way the GBI maintains these fingerprints will be secure.
What is the pleasure of the committee?
Move to pass.
Vice Chair moves due pass of SB 336 LC 298037S. There is a second by Ms. Ballinger. Are there any amendments? Are there any amendments? Any further discussion? Any further discussion? We have a motion of due pass 336 by substitute LC 298037S and a second. All in favor say aye.
Aye.
Opposed? All in favor, please raise your hand. Opposed? The ayes are 5, the nays are 5, the chair votes aye, and the motion is adopted. Thank you, Senator Underman. Thank you, Chairman Welch.
Thank you.
Oh. I apologize. It was next time I should actually put these on. Let me just go ahead for the record and make sure it's clear. All those in favor signify by raising your hand. I'm sorry. Opposed? Yeah, it is. The ayes are 6 and the nays are 4, and the motion's adopted. Thank you. I'm sorry. I'll put these on next time. So let's call Senate Bill 327. Yeah. So I know that Senator Albers is chairing right now himself. He let us know that earlier today or yesterday. So Ms. Miles, I think we're going to go ahead and have you handle the bill. And you want to introduce who you have with you?
Yes, again, I'm Nellie Miles with the GBI. I have with me the Chief Medical Examiner at the GBI, Dr. Jonathan Eisenstadt. And we are sitting in on behalf of Chairman Albers, who's a sponsor. Just want to thank you for the opportunity, Chairman and members of the committee. We bring before you Senate Bill 327. Senate Bill 327 is basically a clarification to the current Death Investigation Act.
Let me just make sure, and I apologize. I want to make sure we're all looking at this at the proper substitute. We're looking at LC 298033S. 8033S. Does anyone not have 8033S at the table? I apologize. Please continue.
Oh, no problem. Again, we bring before you Senate Bill 327, and what this is it is a clarification to the Death Investigation Act. Right now, the medical examiner, there's a medical examiner's inquiry that is required when someone dies under suspicious or unusual conditions. And at this particular point, we've just made a simple change that when someone dies unattended by a physician, that there is no longer, as it was being interpreted, a requirement that our medical examiner's office be notified. And so I have the chief medical examiner with me to just briefly explain the need for it, why we have it, and the change.
Right. So in the majority of the counties in the state, excuse me, the coroner is notified of the death. And the way the law was interpreted was that when unattended by a physician meant anybody who was in their residence, whether they be 40 years old or 103 years old, needed to have a medical examiner's inquiry. And so the change here is that in those cases where there's no suspicion of foul play, the cause of death is obviously natural, the coroner does not have to call the medical examiner's office to report it. The reason behind all of this is it's really taxing resources. It takes time for the investigator to report in our office to compile the report, notify a medical examiner, have the medical examiner decline the case, and then they recalled to the coroner, and that takes a number of hours. So this does not, and there's a statement that's added at the end that this is not saying that the coroner cannot call us. It's basically was being interpreted before that they had to call us. And now we're saying you don't have to call us on every natural death if a doctor was not in the room when the person died.
Ms. Silcox.
Thank you so much. I appreciate you all coming today. And I guess my primary concern would be, especially given the opioid crisis and all that's going on with that, I know a lot of these overdose deaths, that it is necessary to have a medical examiner. And my concern would be if someone overdosed in their home and it would appear to be natural causes, but then, no medical examiner was called, and there were questions found in the investigation of the death that would indicate perhaps that there were drugs involved, but then that evidence might be gone by the body continuing to act. That's my concern.
Sure, I understand. So that's why the coroner acts as the investigating agent for the body itself. They will not be the only person at the scene. The first person usually called is 911, and law enforcement arrives, EMS arrives, and then the coroner will be called if the individual is deceased. The investigation should take place prior to the medical examiner being notified or not. When we're not talking about individuals that are in their 40s and are at home and they may have a history of abusing their prescription medications. This is really going to those, mostly the elderly individuals, 70 years or above, who have a long medical history. We always, the coroner is tasked with investigating that scene. So they look around the scene, they call family members, they call the primary care physicians, they get as much history as they can. And that's what the coroner is supposed to do, is to make a decision at that time. Am I comfortable that this is a natural death? Am I not sure, so I'll call the medical examiner? Or this is definitely not a natural death, so I am definitely going to call the medical examiner.
So does EMS make any kind of determination with the coroner initially, or are they consulted on that at all?
Well, they usually speak to each other, and they do a scene investigation. They look at the medications at the scene. They look to see if what's in the bottle is what's supposed to be in the bottle, if there's any powdery substance, any paraphernalia there. What I would say is that if the cases that they would not be calling the cases that they would not be calling to us now with this amendment are cases that they would be calling us, and we would decline doing an autopsy anyways.
Ms. Kendrick.
Thank you. So I wanted to clarify something you said earlier because I got a little confused. So just to be clear, when you're talking about lines 26 and 27, so everything that happens in lines 11 through 25 requires notification, but you only require the ordering of the medical examiner's report for things that happen in line 12 through 24, correct? Am I interpreting that right?
I'm not sure I understood. I'm sorry.
I understand your question because that's come up before. That is correct, that there is a requirement to make the medical examiner's inquiry, and it would be 1 through 9. So those examples, as a result of violence, suicide, as a result of an apparent drug overdose, you're concerned, they are definitely going to have to make the medical examiner's inquiry. We just wanted to give them the option when it was unattended by a physician for those situations that Dr. Eisenstadt explained.
Okay, but they still have to notify for all of them, correct?
Well, the coroner will be notified.
Right. Okay.
Yes, or the county medical examiner.
Okay.
Correct.
Any further questions? Mr. Trim?
Thank you, Mr. Chairman. Help me again, because I think I know what you're doing, but this also seems like it's potentially a pretty big policy change in terms of when we request a medical examination when somebody dies, so unattended by a physician. What circumstances are we trying to weed out so that we don't have to order these?
Sure. So I sit on the Georgia Coroners Training Council, and I've noticed over the years since I've been here that as new coroners come on, they read this act and they say, this basically means everybody who dies outside of a hospital needs to be called to the medical examiner office. And there's no way that any medical examiner's office could handle all that. So I had discussions with Jason Jones, who was the coroner liaison at GPSTC, Georgia Public Safety Training Center. And what we're doing here is basically saying, if this was a county coroner's office, which is the metro Atlanta counties, the medical examiner investigator would go to the scene, they would look at the scene, and then they would release the body from the scene because they would say, this is an apparent natural death, we have no suspicions. For the GBI, the coroner in the county would go to the scene, and they would do the same exact thing as a medical examiner investigator. So coroner inquest and medical examiner inquest are actually the same thing. And so their training teaches them to go to the scene and say, and put into a category of, this is an apparent natural death. I've looked at everything. I've spoken to everyone I need to. I'm comfortable saying that this is a natural death and not involving a whole medical examiner inquiry.
So I guess the question is, I mean, do you know how long the present law has been on the books as it is?
I don't. I know I've been here in Georgia for 11 and a half years, and it's been there for that long.
So cut to the quick, I mean, what's the impetus now as opposed to sometime in the past? What's changed?
Well, now I've moved up in the ranks, and I feel that this is something that has been on my mind since I've been here, because it really strains our investigators and our medical examiners. For each case that gets called to our office, there is 24 hours a day, obviously, 7 days a week. The investigator has to compile all the information, and then they have to call the medical examiner. The medical examiner then tells our investigator if it's a case to come in or not. They have to call the coroner back. This process takes a minimum of an hour, depending on the case, 2 hours. And we have had so many cases come through that we've declined, all because the coroner says, well, anytime someone dies unattended by a physician, we have to call you. And so we're just trying to make clarification. It's, in all honesty, the impetus is now I feel comfortable that I have a voice that I can come here and make things smoother for the death investigation in the state.
Ms. Gonzalez.
Yeah, I'm still a little bit confused because when I read this, on line 15 that gets scratched out, but that line gets put back into line 25.
Yes, ma'am.
So it's still part of the list.
Right. The reason that we've moved it down is for clarity for the reader, the coroner, because what we've done is we've made it now that 1 through 9 are cases that have to be called to the medical examiner's office. And 10 does not have to be called. It's up to the coroner's discretion. That we just moved it down to make it easier for in the writing of the law.
And the reason why 10 is still there is because a coroner is still required to be notified in each of those instances. It's just the difference between, do you notify the coroner and the medical examiner, or versus just the coroner only?
I'm still not understanding why they wouldn't call for 10.
So in the Metro Atlanta
As
counties,
I look at this list.
understood,
Right.
understood. Right, so in the Metro Atlanta counties, the medical examiner's office would be called. Their investigator would go do the investigation. And in the cases I described of 70 plus years old, no concerns, that body wouldn't even be brought back to the medical examiner's office. For the rest of the state, the coroner is the acting medical examiner investigator. So they do open an investigation into the death, but they do not need to call the GBI medical examiner's office if they're comfortable that this is a natural death.
Is this list sort of in an order of consideration of when you call?
No, ma'am. Again, the line 15 was moved down to line 25, so that when we move over to line 32, we can just say in paragraphs 1 through 9 instead of in paragraphs 1 through 14 and then 16.
Thank you.
You're welcome.
Mr. Bodie.
Yes. Thank you for your presentation. Now, the biggest difference, a medical examiner is actually an MD doctor, is that correct?
That's correct.
But not all coroners are MD doctors, is that correct?
That's correct.
So therefore, when we have a medical examiner there, we have someone with a medical license and experience also, because I know coroners have experience as well, but we have a person that's saying this may have been done by natural causes or it may not. Is that correct?
No, not necessarily, because the investigators in medical examiners' offices in Fulton, Cobb, DeKalb, Gwinnett, their investigators are not medical professionals. They're ex-law enforcement, ex-coroners. So actually going to the scene, they're not medical doctors.
But isn't it true that the medical examiner, the head person, is an MD doctor?
Yes, that's correct.
Okay.
Yes.
But a coroner, the head person, is not necessarily an MD doctor. Is that correct?
That's correct. But again, the medical examiner investigators who do the same job as the coroner are not physicians as well.
The medical examiner in that particular instance is acting as a supervisor to the investigators in some instances. Is that not correct?
In the same way that we act for the coroners. So not every case that is done in one of the Metro Atlanta counties gets called to the actual medical examiner. We rely on our investigators to do that investigation.
But if your investigators had some type of problems, or if they saw something they did not necessarily understand, that medical examination investigator can always call his supervisor, who's a medical examiner, who's a MD doctor, to get clarification. Is that not correct?
Absolutely correct. And the coroners can call us. That's exactly the protocol that we utilize.
No further questions.
That sounded like a Bodie trial line.
No, you made me nervous.
I'm done with this witness. That's the kind of vibe I got on that. I think everybody else did too.
I apologize.
No, don't.
My seatmate said
Please
the same
don't.
thing.
Ms. Silcox, did you have something?
I appreciate it, Mr. Chairman. I was just curious if the GBI had a position on this.
We are the GBI.
Y'all are, okay. I
Yes.
didn't know if you were directly under his office. Great, thank you.
Is there anyone in the audience who'd like to be heard in opposition to Senate Bill 327?
My last question was, I know you talked about protocols. Could you walk me through how would someone go to request a medical examiner's report? Like, who does that? What's the time frame?
Do you mean report or investigation of a death?
I guess a medical examiner's inquiry of that death, which is the language that's used in here.
Sure.
So say, for example, if this bill passes and somebody dies that's unattended by a physician, could you walk me through how would, since the report is not required if this bill passes, how would they go to get that report?
Sure, absolutely. So every single death that happens in this state needs to be outside of Metro Atlanta. We'll talk. This bill really is referring to the GBI medical examiner / coroner investigations. It also pertains to the Metro Atlanta, but like we said, their medical examiners, their investigators handle their own cases. But someone dies anywhere in the state, either the coroner, in Metro Atlanta, the hospital physician, if the person dies in the hospital, can sign that death certificate and not call to us or to the medical examiner. So let's say we're in a GBI county. If someone dies in a hospital, there's no concerns that there was any foul play. It's a natural death. They don't even call. The treating physician will sign that case. So now if we move outside into a place where there's no physician, so someone is found in the street, in their residence, or was unconscious, taken to a hospital and dies within a few hours, the law enforcement is pretty much always called to those cases. If someone is found unresponsive at a scene, the first call is 911. So police show up, EMS shows up, fire shows up. Person dies there, they will notify the coroner. The coroner will go to the scene if the person dies at the scene, will go to the hospital if the person dies immediately upon arrival to the hospital. So the coroner's inquest has begun. That is the same as a Metro Atlanta medical examiner's inquest, because their investigators do the work of the coroner. The coroner will gather the information, will photograph the scene, will talk with anybody who lives in the same residence, through law enforcement, any witnesses. If there's any suspicions of drug overdoses or anything of that sort, they document all of that. So a coroner's inquest has been performed. If it's in subsections 1 through 9, the coroner calls the GBI medical examiner, and we decide if an examination needs to be performed or not. For number 10, if the coroner would like an autopsy performed, they'll call, discuss it with us, and we will do the autopsy. If the coroner is not sure, they will call us, and we will discuss it and decide if we do an autopsy. With this change, if the coroner is like, oh no, this is an individual who's seen every day, has multiple medical problems, I'm comfortable it's a natural death, never done a drug in their life, no suspicions of anything, they don't have to call us. So there's always a coroner's inquest. But it gets confusing. There's always a coroner's inquest, but there's not always a medical examiner inquest. You're welcome.
I see nothing further. Is anyone in the audience like to be heard in opposition to Senate Bill 327? Any opposition? 327, anyone want to be heard? Seeing none, what's the pleasure of the committee? Ms. Silcox moves due pass of Senate Bill 327 by substitute of LC 298033S. Second by the Vice Chair. Are there any amendments? Ms. Kendrick. It's all right.
So say that there is a coroner in a particular county that maybe you just don't trust them. Is there an appeals process? Like, can the family request a medical examination? I'm just worried about.
I understand, believe me, I understand your worries. And really, the wording here is not going to change the process dramatically. It's probably going to, it's going to make it easier for the medical examiner's office. The way that if these cases, if they were called to the medical examiner's office and presented to us by the coroner, we currently are saying this case does not need to be examined. So it's just taking out that step. The coroner is not going to change the story from if they decide to release the body themselves to calling us. Now, if the family is concerned, and we've had families call us and say this doesn't make sense, we will always ask them if they've spoken to the coroner and conveyed that information, because sometimes it's hard to find families. And then, because the family cannot directly request it of us, they have to go through the coroner, and the coroner will then call us. If they're not comfortable with that coroner, we say, have you spoken to your local law enforcement? And if the family has presented to us a big concern, and we agree that that concern is something that needs to be examined, we will then take the initiative to call the coroner ourselves. So there's no standard protocol, but families can call and say, we're concerned about X, Y, and Z, and then we just ask them if they've called the coroner or local law enforcement to go through the right chain of command, and then if they say they have but they're getting pushback, we will call the coroner and discuss it further with them.
We have a motion and a second. Are there any amendments? Seeing none, any further discussion? Seeing none, all in favor of the motion signify by saying aye. Aye. Opposed? The ayes have it, and the motion is adopted. Who's carrying this?
Colonel Hitchens.
Thank you. Is Judge Goslin still here?
I am.
There you are. Judge Goslin is here as our Judge of the Week. Thank you, Judge, for being here and being a resource to the committee. Any further business? Seeing none, we're adjourned. Thank you.